mistrial in the YSL RICO trial involving Atlanta rapper Young Thug. Now defense attorneys are learning about a second private meeting before the one that led to the recusal of Judge Uriel Glanville. Defense attorneys allege the comments made behind their backs are possible grounds for a mistrial. Judge Paige Whitaker said she would be, quote, a little hot under the collar about that meeting transcript if she were a practicing attorney, adding she will take that into consideration as she reviews the motion.
Meeting that occurred on Friday.
Right. This is
Or Monday.
I'm sorry, just so that we're clear for record purposes. This is the transcript I gave y'all at the end of yesterday that reflects had said, oh, yeah, we had, and in court on the record, but ex parte discussion that led to the Monday, June 10th ex parte. So that's what you're talking about?
They'd be more artful, yes.
Okay.
Second ex parte meeting that happened on July the 7th, the Friday before the other ex parte meeting on the 10th. It starts with Mrs. Love. Judge, the reason that I specifically wanted to talk with you is that I have a concern about the representation being made of the representative. I am concerned, I am sort of not. I wanted to just bring it to the court's attention. Mr. Melnick has not conveyed to either Ms. Hilton, myself, or any member of the state any legitimate concern that he has regarding Kenneth Copeland's testifying. What we have seen is physical persons beyond, besides Mr. Copeland, that would indicate that Mr. Copeland is not Mr. Melnick's primary priority. What we do know is that the fact that he willingly and wanted to leave, number one, he left twice after the court ordered him to speak with his client, and it would seem his actions convey that it is not Mr. Copeland's best interest that is his priority. Mrs. Hilton was out speaking with Mr. Copeland at Mr. Copeland's request at the time that I announced that Ms. Hilton was calling Mr. Copeland. What I did not know is that she was trying to tell you to give us a minute because Mr. Copeland was vigorously, and I will let her speak out to how that went down, trying to get her is there to say to her something that Mr. Melnick had just said to him that did not come from any of us. The judge, Glanville. What was that, Miss Hilton? Mrs. Hilton. So let me just put the order of operations. I got up because Deputy Chief Long said he wants to talk to you. Come out right now. So when I went into the room, Melnick either came in or came outside. And what Mr. Copeland said, and I think that he wanted to get some autonomy, I want to talk to you. He's like, I've already talked to you, but I want to talk to her. And Mr. Melnick kept blocking him being able to talk to me. So eventually, you want to talk to him, so I'll step out and you can come in. Mr. Melnick spoke to him, and I think it was trying to eat up time because he knew that you were coming out. So by the time I got back in there and he started to talk, that is when everyone said, come on, the judge is waiting, and that's why he stormed in angry. Mrs. Love. He being Mr. Copeland, Mrs. Hilton, because I think he was trying to convey to me some concerns he had. And so I was trying to have that conversation because Mr. Copeland and I have been having really good conversations since Friday, very, very good conversations. Just not even about the facts of the case, but just life experiences. So I think I was building a rapport with him such that he thought I lied to him. So I was trying to explain to him Mrs. Love. And by that, she means today. Mrs. Hilton, today about what was going to happen. Mrs. Love, because of what someone conveyed to him. Mrs. Hilton, we believe that something was being conveyed. What happened is, as Mr. Copeland was walking back into the courtroom, Mr. Melnick and Julia Mrs. Lasquat would have to confirm this, but he said they are going to hammer you. And that made me ask Miss Love, did you say something about hammering him? And I don't know who. Mrs. Love, nobody did. The judge, Glanville, it doesn't make sense you would say that to him. Mrs. Love, we never. Judge Glanville, but anyways, okay. Mrs. Hilton, so whatever that communication was, that's when he stormed in and got angry. And the results I got was what he gave when we started. So at this point, I'm very concerned. Mrs. Love, he mean Mr. Copeland stormed in and got angry? Mrs. Hilton, the timing of everything is very erratic. We laid it out on the record earlier about what happened, and I don't believe that Mr. Copeland's best interest is being served at this moment. Given that, Mr. Melnick was willing to take a vacation and let him languish in jail, and that is not. We have communicated that we never wanted Mr. Copeland to go to jail. We don't want him in custody. We don't want any of that to occur. And so, Mrs. Love, and Mr. Melnick has not spoken. He has not relayed. What we did get during the break was an email from Mr. Melnick. I don't know if he had to have been blind copying someone else. The only two people I could see on the email were Miss Hilton, myself, but they referred to me in the third person and said, these are the communications between myself and Mrs. Love. So I asked Mr. Melnick, who interests are you concerned by Mr. Steele and Mr. Swartz? Because prior to, and this is not the first time Mr. Copeland has said he doesn't represent me. This is not the first time Mr. Melnick has, and let me be real clear, when he spoke of what was happening before him representing Mr. Copeland and he told me that he didn't represent Mr. Copeland. He told me. Judge Glanville, Mr. Melnick told you? Mrs. Love, yes. Mr. Melnick told me previously that he wasn't representing him. Judge Glanville, you would not speak to an unrepresented party. I know you know enough of the rules to know that if you thought or intimidated that somebody was represented by counsel, you would go ahead and let them contact that lawyer. Mrs. Hilton, or Mr. Copeland would have said, because I don't know, because he's not charged, if we would have to. Mrs. Love, right. Mrs. Hilton, because he's not charged. Judge Glanville, I don't think you have to because there's no pending charges. But if he told you I got a lawyer, I don't want to talk to you. Mrs. Love, we would have left. Judge Glanville, because people in counsel that they have under retainer or something else, or they say, hey, I got a lawyer that I use for everything and I want to talk to him. I'm not comfortable talking to you unless my lawyer is present. Mrs. Hilton, we have done that with a number of our witnesses here, so this would have been no different. Mrs. Love, exactly. And we would have, I'm sorry, I don't mean to cut you off. Mrs. Hilton, no, go ahead. That was it. Mrs. Love, we actually communicated, especially when either they are incarcerated or subject to having their sentence revoked as the result of their testimony because they plead guilty here. We only reach out to them through their attorney because we want the attorney to speak to them and for that to be, because that's the best way, in our opinion, to get after that at least truthful testimony. So in their particular instance, there were not, that number one, there was not that communication made by Mr. Copeland that there was ever a need for that. And two, there was not a need for us to be concerned about it because he doesn't have charges. Mrs. Hilton explained to him at length that whatever happened that he did in 2015, which is all we're going to be talking to him about, the statute of limitation has run. He didn't do the murder. We know that. So I don't want to get into the facts of anything. What I'm trying to get at is the fact that Mr. Copeland, I believe Mr. Melnick has inserted himself in a way that jeopardized the best interests of our witness. I believe that in conveying to the court that Ms. Bumpus is going to stand in his stead. Mrs. Bumpus has been, she was, what is the word I'm looking for? The sheriff had to speak to her because she was in the courtroom trying to hug Jeffrey. Mrs. Hilton, no, she hugged DeMonte Kendricks. Mrs. Love, I'm sorry. Mrs. Hilton, in fact, she hugged DeMonte Kendricks and hugged Mr. Williams. And that's how Captain Kendall saw her. And Captain Kendall had her taken out. Mrs. Love, she expressed dismay and concern in challenging her right to go interact in that manner with the defendant. So our concern is that it is not Mr. Copeland's best interests that are being represented, and that not only is that the case with respect to Mr. Copeland, who we have no interest in prosecuting, but there is a tampering of sorts going on in this person's inserting himself where Mr. Copeland has been reached out to speak to Mrs. Hilton and their communication being blocked by someone. Mr. Copeland didn't reach out to. You notice no one said Mr. Copeland called me. He never said, when we put on the record when Miss Hilton said, the way I understand it, Mr. Melnick reached out to Mr. Copeland because the first time we heard an assertion like, oh, he's going to plead the fifth, is when Mr. Melnick sent an email to Mrs. Hilton and myself and had copied on it Mr. Steele and Mr. Swartz last night. Judge Glanville, why would he have done that given Mrs. Hilton? And that's the state's concern. Mrs. Love, that's the point. Judge Glanville, but here's the challenge. The challenge is you have privileged communications unless you've got him being the client, disclosing to a third party that wouldn't be subject to the privilege. That is the only way you're going to, Mrs. Love. I don't disagree with that at all. But if Mr. Melnick and the thing that got me the most is Mr. Melnick not looking at Mr. Copeland saying, Mr. Copeland, I want you to stay out of jail and I will be here with you. And if they're asking you anything that touches upon something that you and I talked about, I will stand up and assert your right. He didn't do that. What he did was he looked over at two people and said, like, I did what I could, shrugged his shoulders, held up the palms of his hands like this, as to say, I tried. There is no reason he would be looking to the right to counsel for the defense like I tried, after Mr. Copeland said he was going to testify. That doesn't make sense. Judge Glanville, well, there's a lot of noodle that they have asserted themselves. Some of the defense counsels have asserted themselves in this particular process, and that's what, Mrs. Love, my concern is Mr. Melnick's assertion of himself. Judge Glanville, what are you asking me to do? What are you asking me to do? And what do you think that I can do? Mrs. Love, that is the exercise. This is the homework for tonight. I want to let the court know that this is what we're looking into right now because there is a remedy. Because I have faith in our law. I love this thing and I know there is a remedy because this can never have been the first time this happened. It has been addressed. I just have to find it. But I didn't want to be looking for something and not let the court know what I'm looking for, so that you are caught off guard when Monday morning or Saturday night or Saturday afternoon we find it and send it to you. Judge Glanville, okay. Mrs. Love, so thank you for allowing us to audience with the court. I just want to make certain that we did it properly and we'd had everything on the record. It is our witness. We have conveyed to him that he is shielded from prosecution for anything that he's talked about on the stand. And any use of that. And the things is that we won't ask him that. But this is what he said. Y'all might not, but they might ask me about some things that I have to assert my right on. And that would question basis. What is he being influenced to do? We believe by Mr. Melnick is, and it's through Mr. Melnick, because as you saw, Kenneth Copeland said, I will testify. Mr. Melnick, even after that, said he's asserting his fifth. I'm going to go talk to him. Logically, one would think that as long as Mr. Melnick is concerned about Kenneth Copeland freedom, legal freedom, and his exposure, as long as those were addressed, Mr. Melnick should be saying, I am here with you. If there's something that I know will put you in jeopardy, I will stand up and stop you. But right now, I would rather you stay out of jail. Instead, you give Mr. Copeland, and you can see through his body language, he gets there in court and he's smiling as if making a show of being taken into custody after this. And the man don't want to be in jail. He said it. Didn't he say he don't want to be in jail? Miss Hilton, that is his biggest fear. Mrs. Love, that's his biggest fear, and now he's in jail after Mr. Melnick asserted himself in this process. So we have to go figure it out. I'm not just laying it in your lap saying, go fix this. I'm just bringing this to the court's attention. This is a grave concern. Mrs. Hilton, she's about to lose her mind because her biggest concern is that Mr. Melnick is actively harming a human being, and that's what she's mad about. I'm mad because it's stopping our trial and it's wrong, and that is not how the law is supposed to work. So we have two big old grave concerns that we are working to remedy right now. Judge Glanville, okay, well, like I said, I think you brought your concerns to me. Without more, I don't know what else I can kind of do in terms of that. My comment today were predicated on a lot of stuff that's going on in the background, and it shouldn't have to do anything with you all's case. It really shouldn't, but I think it does in some way outside agitators. Mrs. Love, that too. Judge Glanville, and everybody else who I think are trying to influence. Mrs. Love, that's absolutely happening. Mrs. Hilton, there's a lot going on. Mrs. Love, there's a presence. Yes, that is all I'll say. Judge Glanville, but I see it from just being in the courtroom and tracking. But okay, if you find anything, we'll see where Monday leads us. And like I said, since we now know he's going to potentially invoke, we'll see what his pleasure is. Mrs. Love, just the idea of someone sitting in jail throughout this trial, but if that's what he's being counseled to do and that's what he does, that's just wrong. It's wrong because a member of the bar is, in my mind, creating the circumstance, He's going to do what the person he trusts to have his best interests at heart tells him to do. And that he doesn't have to tell us what he is concerned about. And you can sit there and when he sees the train coming, stand up and say stop. But he's got a vacation to go on, so he can't be there. So Mrs. Bumpus is going to be here. Mrs. Bumpus hugging Mr. Kendrick and Mr. Williams is going to be here representing the interests of Kenneth Copeland, who is supposedly to testify against Mr. Kendrick and Mr. Williams. That is where we are. That doesn't pass a smell test. And that is the second ex parte. Well, that's the first ex parte meeting before the second secret ex parte meeting that we just found out about in court the day before yesterday.
We were made aware, leading to the recusal of Judge Glanville, that there was an ex parte meeting that occurred on June 10th, Monday, June 10th. We were not told by the state, we're not told by the judge that that had occurred. We found out about it, luckily, and by happenstance. We then demanded a transcript. We complained about said ex parte, inappropriate ex parte meeting. At no point, when the court finally acknowledged that there was an ex parte meeting that occurred on Monday, June 10th, at no point did the court or the state at that point acknowledge, oh, by the way, there was another ex parte meeting that occurred on June 7th. We, after finding out about one ex parte meeting and having to drag the truth out, we sat there and the state and their co-conspirator, the trial court, were silent about the first ex parte meeting that happened on June 7th. What happened in that meeting on June 7th? The state went in and disparaged defense counsel. The state went up there, trashed a fellow member of the bar, Mr. Melnick, trashed another fellow member of the bar, Caleb Bumpus, presumed the guilt of all these individuals, including my client, Shannon Stillwell, and all but accused myself and Mr. Steele of being co-conspirators in this YSL enterprise. And the judge agreed. And the judge said in this ex parte meeting, yes, I've observed these things. Of all the defendants, the judge presumed the guilt of myself and co-counsel, Mr. Steele. And all this, people have been saying to me throughout this whole trial, why does Judge Glanville have it out for you? And it never made sense. And I don't assume bad motives of anyone. Why did Judge Glanville, when you did nothing wrong, try to throw you in jail? Accuse you of cussing him out in open court when you didn't do anything? Why does he always tell you, yell at you, tell you to sit down and be quiet? Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right? And I didn't have an answer. And then yesterday I received, and I appreciate that, Judge. I appreciate someone finally being open about what's going on here. And I received a transcript. And in that transcript, the trial judge, who's not only assuming the guilt of my client, but is assuming the guilt of me and my friend, Mr. Steele. This is gross. This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. And the bottom line is, there's a lot more discussions that need to be had about this. But the bottom line is, if you ask me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on in trial. the judge that says not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions.
All right.
Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay. It's not okay. And it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
My head steam cut off my bald head all night. Nothing about this is okay. Yes, we need to revisit everything. That's my stance.
Okay.
Thank you, Your Honor. And we're getting that ready as we speak to present to the court. And I'd also like to thank Your Honor for the reminder regarding professionalism. I was going to ask that the court require that we all adhere to that. Being called co-conspirators is not something that I would expect to have heard, no more than I would expect to level of assertion that Mr. Sharp is a defendant. So I'd ask that that all sides be required to adhere to the court's admonition.
Okay, well, again, the transcript will reflect what was actually said in there, and there are some allegations that if I were an attorney and it were leveled against me, I mean, I am an attorney, but you know what I mean, practicing in a case, I would be a little hot under the collar as well.
Ron,
Yes, sir.
if I can address the court briefly. I filed a supplement to the Mr. Kendrick's motion for a mistrial this morning. I just want to make sure the court's aware of it.
I am aware of it. I have not yet had a chance to look at it, but that's, got it.
Thank you, Your Honor. Mostly I want to make sure I bring it to the court's attention because, again, and I've followed the request of the court to not argue what's already in the papers. So the court understands that based on this additional information that we learned about the July 7th meeting, that my client has been consistently denied his right to a fair tribunal. It's been a due process violation. I, like Mr. Sharp, am extremely upset having read that transcript. Myself and my fellow outside agitators here, I assume that they are upset as well. And
Honestly, I don't think that reference was to anybody who is a member of the bar. I think that there have been times in this case where members of the public are in the courtroom, which they are, of course, entitled to be, but communicating in ways that are not appropriate.
well, you know, the problem, Your Honor, is it's a Parte meeting that should probably have never taken place. You were not there. I was not there. My fellow outside agitators weren't there. We don't have a video of it, so I have no idea specifically if that was not referred to us. We don't know, do we? We don't know. And what I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to his ability based on the evidence and the law before him, and now I have been made to look like an idiot. So
Well,
I do not believe that this trial should continue, Your Honor.
I understand. Thank you. I'll take your supplement under consideration. Like I say, I haven't, obviously you just filed it and I haven't had a chance to look at it yet, but I will consider that in the overall context of the motion I was already considering. And, you know, I don't know that everybody's not going to want to come up here and do their 5 minutes of how outraged they are. Yeah, if y'all feel like you need to get it off your chest, come on. Now's the time.
I got one more thing to say. And then I'll sit down.
Okay.
And I don't believe that this is performative outrage, Your Honor.
I mean, I don't either.
Okay.
I don't either. I already said I understand.
In July of 2023, after months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline produced from the state. He refused to do so. And you know what Judge Glanville's response to me was? When I will tell you. I will tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, coming in. If this was a civil trial, if it was about money, I would keep it out. But since it's only about Mr. Kendrick's life, that last part obviously wasn't in there. But if this was a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial. But what did I say to people? Chief Judge Glanville is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right, well,
What do I say?
I don't know. Obviously, I don't know what to say right now either.
Well, there you have it. The state, in a second ex parte meeting, which was the first ex parte meeting that we're just now finding out about, bashing the defense lawyer, definitely against the bar. Let me know your thoughts. Put them in the comments below. Don't forget to hit the like and subscribe button, and thank you for tuning in.